Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Hospice, TPE, CERT, SMRC, SFP, PPEO, and UPIC audits, top denial reasons, and the possible impact of these audits on other enforcement activities. Today's presenters are Lester Johnson and Matthew Catoe. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we'll address as many as possible at the end of the presentation. I will also be sending out copies of this presentation tomorrow via email. So without further ado, I present your speakers, Matthew Catoe and Lester Johnson.
Thank you, Gio. Good morning / afternoon to everybody. This is Matthew Catoe. I'll be taking the first half of this. If we can go ahead and get into the next slide. As a brief disclaimer, we do want to point out that everything contained in these slides is designed to be advice only, or it is not legal advice. While Lester and I are lawyers, we are not your lawyers until you choose to engage and retain the firm in full. To open with our slide deck today, we are going to cite this quote from Supreme Court Justice Gorsuch, which states that criminal laws have grown so exuberantly and come to cover so much previously innocent conduct that almost anyone can be arrested for something. We use this as a tone setter for most of our audit slide decks as a reminder that there's a lot of expansion and new initiatives coming out around the laws that underlie these audits, and we want to make sure that people who attend our webinars are aware that they are expanding, and more cases are falling under a previously thought to be okay framework for one or more reasons. Next slide, please. So as a brief overview, back in September of 22, Deputy Attorney General then Lisa Monaco issued an update on her previous guidance. The Department of Justice the Department of the Attorney General, the Department of Justice, and the Department of Health and Human Services, a lot of acronyms. First priority in corporate criminal matters is to hold accountable the individuals who commit and profit from corporate crime. Corporations can best deter misconduct if they make it clear that all individuals who engage in or otherwise contribute to criminal misconduct will be held personally accountable. As a result, the personal liability of all home health and hospice agency owners, employees, and contractors has dramatically increased and has remained at its standard highs since this new guidance came out. You cannot expect to avoid personal liability by hiding behind an organization settlement with DOJ and or the OIG. Generally speaking, in making determinations, the corporation's compensation agreements, arrangements, and packages are all assessed when determining penalties to be levied against current or former employees, executives, or directors. So we want to point that out as a reminder to say that just because the company settles does not mean you as an individual entity get away from all liability associated. Next slide, please. We do want to point out that enforcement initiatives are accelerating in the post-COVID era. On your screen is a graph that demonstrates the civil fraud recoveries up to fiscal year 2024, where we closed with about $2.9 billion in recoveries. The federal government recently announced the 2025 numbers where they said civil cases involving fraud and false claims against the government exceeded $6.8 billion with a B dollars in recovery over the course of fiscal year 2025. Of this amount, $5.7 billion is attributable to healthcare-related cases and matters. During fiscal year 2025, 1,297 whistleblower cases were filed, which is the objectively highest number ever recorded in a single year. And during fiscal year 2025, the government, including the Department of Justice and other associated parties, also opened a new 401 cases or ongoing investigations, specifically citing targets within the current administration's policy objectives. The link to these facts, the DOJ publication, and the administration's current policy objectives is on your screen in the event that you would like to check these policy objectives for yourself, as the Trump administration has currently made them available to the public. Next slide, please. Healthcare fraud remains a focus of the DOJ's fraud section. As of fiscal year 2024, healthcare fraud criminal prosecutions made up the vast majority of all criminal cases pursued by DOJ's fraud section. We are expecting to see a similar take as the administration wraps up what they claim to be an enforcement mechanism for the administration as outlined. On your screen are different areas that the government uses to enforce these criminal fraud sections, including the FCPA, the Foreign Corrupt Practices Act, which unit prosecutions focus on global corruption prosecutions, as well as the MIMF, the Market Integrity and Major Fraud Unit. This unit focuses on bank fraud, mortgage fraud, federal program fraud, securities, commodities, corporate investment, and crypto-related cases. We have seen at least some enforcement out of this agency as it relates to things like post-COVID grants, which have not yet gone away in terms of healthcare fraud and abuse enforcement. More recently, we've seen 147 individuals charged through healthcare fraud unit investigations, and 165 individuals were convicted either at trial or through a guilty plea. These charges and conviction rates are near double the MIMF, which focuses on fraud and banking in the federal sector, as we previously determined. This is noted to be an uptick in enforcement activity, both in the civil and criminal arena. We have on your screen the particular fiscal year 2025. This is taken from the civil matters, but this is key TAMs, as key TAMs do often result in both a civil and criminal proceeding against the alleged violating party, because the damages at issue are usually high enough to perk the government's attention and be known as government intervened cases. You'll notice there are 1,297 new key TAM matters as of fiscal year 2025, where the U.S. intervened. There were a total of $3 billion with a B, $51,734,829 that were intervened on or otherwise pursued, and the relators, the individuals who relate these causes for concern to the government entities, were awarded approximately $286,054,233, where the government otherwise intervened or pursued the case that they brought before the government, which makes up a large portion of the $330 million total on your screen. As a brief reminder, just because the DOJ pursues a civil key TAM or the associated actions therewith does not mean that a criminal case cannot be pursued both federally and at the state level for the same nexus. They are separate and distinct matters and can all be levied against your organization at once. And so we point this out to once again set the tone to make sure that you are on the up and up with all of your auditing and in compliance with the Federal False Claims Act, Anti-Kickback Statute, and Stark Law that make up the underlying authority that most agencies use to conduct these audits. Next slide, please. As a brief enforcement overview, looking back at federal criminal prosecutions of American companies, we're going to start with good old fiscal year 1992. Most of the organizational offenders were companies that were criminally prosecuted and subsequently sentenced by federal courts. About 88% of them were domestic in some form or fashion, privates, 92% in some form or fashion, and small, with less than 50% of employees. That number was encompassed by about 78.4% of the prosecuted individuals. An overwhelming majority of organizational offenders, some just shy of 90%, did not have any compliance or ethics program in place at the time in which they were prosecuted. And only 11 of the almost 5,000 organizations criminally prosecuted received a sentencing reduction under the U.S. sentencing guidelines for having an otherwise effective or implemented compliance and ethics program. Only 1.5% received a sentencing reduction for disclosing an offense to the government prior to the government investigation, as well as fully cooperating and accepting responsibility. While criminal prosecutions of companies have generally declined, the DOJ's focus on individuals involved in criminal conduct has increased. This means that they have shifted their focus from the actual corporation to the individual entities. Approximately 0.2% of organizations were criminally prosecuted, receiving a sentence reduction under these guidelines, and they want to point out that they are looking more towards the individual bad actors, the doctors, the nurses, physicians, the physicians' assistants, and other entities who they can put names to that are not some faceless corporate entity. Next slide, please. So, generally speaking, most of the administrative audits that we are seeing are falling under ADR, TPE, or UPIC audits. The primary reasoning for most of their denials are that the skilled nursing services were not medically necessary, that the initial certification period was missing, incomplete, or otherwise invalid. Therefore, any recertification episodes are subsequently denied as well. The medical documentation submitted did not show that therapy services were reasonable and necessary, and at a level of complexity that requires the skills of a therapist, as well as the requested medical records through an ADR were not received within the allowable day or time limits. This is a citation to deadlines. You want to make sure in the event that you receive an audit of any kind, you very quickly and appropriately contact healthcare counsel who are skilled in handling these matters so that you can not only guard yourself and your organization as an entity, but also that you are keeping a close tab on all document communications that come in so that you can appropriately guard your deadlines. As you can see on your screen, pre- and post-payment review at the MAC and UPIC usually caps out just at the 45-day range. That means 45 days to get the records together, compiled, reviewed, and submitted to these entities in compliance with the current ongoing enforcement initiatives. So you want to make sure that you are on top of all of your deadlines as soon as you become aware of them. And finally, the last and most common reason that we're seeing is deficiencies in the face-to-face encounter. This is a broad category because it is used broadly by denial rationales. Generally speaking, they will say that there is some kind of other generalized deficiency somewhere within the face-to-face encounter, but they will not overly specify insofar as to what that may or may not be. Next slide, please. So on your screen now are some examples of criminal cases that have resulted that have come about, as a result of some of these enforcement initiatives. Out of the Eastern District of Texas, you can see that the owner and operator of 5 Houston area home health agencies was sentenced to 480 months in prison for conspiring to defraud Medicare and the state of Texas Medicaid programs for more than $17 million with an M dollars. According to the plea agreement, the defendant and his co-conspirators obtained patients for these home health agencies by paying illegal kickback payments to patient recruiters and his office employees for hundreds of patient referrals. They also paid Medicare and Medicaid patients by cash, check, Western Union, and MoneyGram for receiving services from his family's home health agencies in exchange for the ability to use the patient's Medicare and Medicaid numbers to bill the programs for home health care and provider attendant services, or PAS services. Some of this was directly paid back to the patients for recruitment and referring other Medicare and Medicaid patients to his agencies. This was pursued criminally, and the individual was prosecuted to the full extent of the government's authority under the False Claims Act and Anti-Kickback Statute, among other things. A second case out of the Eastern District of Texas on your screen towards the bottom is the defendant was charged by indictment with conspiracy to commit healthcare fraud itself, and conspiracy to pay and receive kickbacks in connection with an alleged fraud scheme to obtain over $1.5 million in Medicare Medicaid funds. As charged in the indictment, the defendant, owner of the home health hospice service, billed Medicare and Medicaid for home health services that were not provided and or medically unnecessary based on illegal kickback payments to marketers and patients. Once again, as a reminder, both of those actions fall under the general broad scope of what we see as a very common enforcement action. And we remind everyone attending this webinar to make sure that if you bill one of the federal programs, to ensure that that program service has actually taken place as your billing and coding documents say that it has. Next slide, please. A few more examples on your screen, one more out of the Eastern District. The owner and operator of a Houston home health company allegedly paid recruiters and doctors to bill Medicare for home health services using Medicare beneficiary information, regardless of whether they needed home health care or not. Out of the Northern District, there was one physician and 2 nurses who were found guilty of healthcare fraud, and one physician and 1 nurse was found guilty of conspiracy to commit healthcare fraud for their roles in the following scheme. According to evidence presented at trial, the defendants engaged in a scheme to defund Medicare and Medicaid by submitting and causing the submission of false and fraudulent claims to Medicare through a home health agency and a physician house call company. Excuse me. The evidence presented at trial showed that one of the defendants, a doctor of osteopathic medicine, certified Medicare beneficiaries from whom he had not seen and did not care to see for medically unnecessary home health services that often were not provided. They later falsified nursing notes to make it appear as if Medicare beneficiaries were qualified and were provided skilled nursing services, even though these services never occurred and were not otherwise duly rendered. Out of the Southern District of Texas, the owner of a home health hospice agency allegedly paid marketers and group homeowners for Medicare beneficiary information, which was later used to bill Medicare and Medicaid for home health services that were either not provided or did not qualify for coverage and payment. The defendant owner also allegedly personally falsified home health patient assessment information and rates from Medicare, and he instructed agency employees to falsify home health certifications and forge physician signatures. I hope I did not have to inform everybody on this call how illegal that is and how quickly the government will come looking for their money if they believe you are intentionally defrauding them. Next slide, please. Another batch of administrative audits that we've seen are Hospice Special Focus Program Audits, or SFP audits. They've been designed to monitor hospices identified as quote-unquote poor performers based on selected quality indicators. These indicators selected for review under the SFP audit are given additional oversight intended to enable performance improvement. Hospice agencies unable to resolve the deficiencies that led to their review may be terminated from their participation in the Medicare program. CMS also, under an SFP audit, has the option of imposing one or more alternative enforcement remedies in addition to placing the provider on a termination track. Hospice PPEO started in 2023, and prior to its implementation, CMS received numerous reports of fraud, waste, and abuse related to hospice services over the prior 12 months, along with the simultaneous growth in the number of enrolled hospices, which means more hospice entities and more reports of fraud, waste, or abuse that CMS determined was inconsolable with itself. Excuse me. PPEO assesses agencies in Arizona, California, Nevada, and Texas. These are new agencies or those that have undergone a change in ownership. We are seeing very small numbers of claims being reviewed and aggressive actions being taken under this program, up to and including a full revocation proceeding. One of my most recent revocation actions stems from a PPO review of only 8, count them, 8 claims. The revocation was based on a, quote, pattern or practice of improper billing based on these 8 claims alone. More than ever, new agencies, and all agencies for that matter, must ensure that every claim is bulletproof. The primary denial reasons we're seeing under SFP and PPEO include that the documentation does not support prognosis of 6 months or less. The physician narrative statement is not present or otherwise valid. The election statement does not meet statutory or regulatory guidelines. Excuse me. And there is no certification for the dates billed, as well as a reduction in hospice continuous care hours. Next slide, please. And finally, the good old TPE audit, which everyone desperately loves and very much wants more of. TPE audits are serious business. They are intense, time-consuming audits that involve the possibility of multiple rounds of review, referral for additional audits, placement on prepayment review, each requiring more time and resources. Your agency may also be looking at suspension or revocation. TPE denials primarily involve eligibility, face-to-face documentation, and errors assumed to be therein, or missing and incomplete certifications or recertifications. TPEs may be initiated because your agency is found to have historically high denial rates, billing practices that vary from your peers, or when there is evidence that suggests potential fraud. You will receive notice that your agency has been selected for the TPE, followed by additional document requests. These ADRs may come in across multiple days, have different deadlines, and cover varying certification periods. Until the error rate drops below a certain threshold, which may differ between the MACs and is not generally publicized, your agency will be subject to additional rounds of TPE, up to 3 rounds. Each of these provides an opportunity for education to discuss any denial reasons, documentation issues, or improvement steps that can be taken to avoid further denials. Next slide, please. We've also seen an uptick in comprehensive error rate testing, or CERT, audits of hospice claims. Primarily, the CERT denial reasons include inadequate physician certification or recertification, an inadequate beneficiary election form, a physician certification was signed and dated after the claim was submitted to Medicare and Medicaid, as well as inadequate or otherwise missing face-to-face documentation. The graphic on your screen is pulled directly from the CMS published CERT summary of fiscal year 2025, and you can see on your screen that over 53% of these claims are accounted for with insufficient documentation errors of some kind. This can usually be related to some missing document or some kind of LCD compliance matter that is not appropriately encapsulated within the patient's medical record, on which the government will turn around and say this fails to meet one or more criterion, and we are denying on these grounds. Medical necessity makes up the next biggest category, coming in at 15.3%, as well as completely absent or missing documentation coming in right behind that at 12%. Incorrect coding makes up another 11.1%, and 8.5 is a series of miscellaneous categories that they did not see fit to break out, usually related in some form or fashion to, as we said above, physician certification signed and being dated after the claim was submitted. You generally want to take these numbers and turn inward and make sure that when you are submitting claims to any federal or state program, Medicare, Medicaid, or any entity that claims to touch a state or federal dollar, make sure your documentation is there and is in compliance with all of the stated LCDs and LCAs to the best of your ability. It is always better to be overly detailed than it is to be under detailed. We have cases in front of us right now where we have to have some pretty hard discussions with clients saying, I can argue several things on your behalf. I cannot argue the absence of necessary documentation. You either have this piece of paper filled out the way it's supposed to be, or you don't. And what you have provided to me says that you do not. I can't really argue around that. And so we cite it here to point out that we want to make sure everyone is aware and on top of all of their CERT materials. Next slide, please. SMRC audits conducted, these are supplemental medical review contractor audits of hospice claims. Their primary denial reasons generally are lack of medical necessity, a failure to appropriately respond to the documentation request, as well as certification deficiencies. We would also like to point out that should a hospital provider do poorly in a SMRC audit, the negative results of the audit may be used as part of the justification cited by CMS when placing a provider on suspension or proposing that that agency's enrollment be revoked. I would also like to point out that we are noticing an uptick in CMS and their contractors attempting to utilize the online database known as KiteWorks for online submissions. These document requests do look different from what most providers are usually seeing, and they are expected to be, the providers are expected to comply with KiteWorks electronic submissions. You need to make sure if you receive documentation that appears to be official in origin and it is asking for additional documentation related to one or more of your patient claims be uploaded to KiteWorks, that is very likely an additional documentation request. We have had several claims now and are seeing an uptick in them where in an attempt to, they say modernize, I say make more complicated, the additional document request process, they are saying failure to upload these documents into KiteWorks electronically is considered failure to respond to an additional documentation request. So please, please, please read all of your mail as it comes in, especially if it looks federal or appears to be sent on behalf of CMS or one of their contractors, Hugh Laurent, Noridian, whomever else may be involved. And if you don't understand it or are confused, please feel free to book a consult with our firm or a similarly equipped healthcare regulatory firm to read and translate this letter for you. We do not want to start off on the wrong foot of a SMRC audit by failing to respond to a document request that was otherwise sent along with these new initiatives. Next slide, please. The next type of audit we're seeing is a Unified Program Integrity Contractor, or UPIC audit of hospice claims. Although administrative, the primary purpose of UPICs is to detect, deter, and prevent fraud, waste, and abuse in the Medicare and Medicaid programs. Every UPIC contractor is responsible for handling federal program integrity audits of both Medicare and Medicaid claims within a specific area of the country. The top reasons we're seeing for denials under these administrative audits are eligibility deficiencies, where individuals were improperly admitted to hospice, even though the beneficiary did not meet the criteria to qualify as terminally ill, as well as uninformed consent to elect a Medicare hospice benefit. I've seen this show up as that benefit form or the elections that the patient or their power of attorney or next of kin or whomever else is objectively not in the medical records. Whether it exists or not is a separate question, but it was not provided to the UPIC as part of their original ADRs, as well as billing for a higher level of care than medically necessary. Audits have found that the level of hospice care provided was higher than what they determined to be medically necessary. And finally, billing for hospice care provided by an unqualified or unlicensed clinical personnel. All hospice personnel must be licensed and may only perform, tasks within their current scope of practice. On your screen are the citations to the Medicare Benefit Policy Manual and the Code of Federal Regulations, respectively, that we've seen appear in these UPIC audits and be used as justification for the UPICs auditing these entities. Next slide, please. And now our good friends at the OIG have decided they want to uptick their hospice claim inquiries. OIG has ramped up its auditing of hospice agency claims around the country. They've noted several recurring errors, primarily related with the hospice eligibility requirements, in that the clinical records do not support a terminal illness diagnosis, the physician certification or recertification did not meet Medicare's requirements, and documentation of a proper face-to-face encounter was otherwise missing. These are resulting in categorical denials associated with eligibility, documentation, and the level of care provided, or not otherwise being supported by the medical records that were reviewed by OIG. OIG audits can be more time and resource consuming than many other audits. Although we recommend engaging legal assistance to address audits of all types, it is especially important when handling OIG audits. I used to work with the Department of Health and Human Services, OIG, both their investigation and legal team. I can assure you that several claims of whether or not you were a good person or you meant to or didn't mean to do X, Y, Z, or several other claims that are standard appeals that a lot of clients want to lean on, including but not limited to objective healing of the patient, a lot of times don't get you out of hot water because OIG are very technical with their investigations and their audits. If you are under an OIG claim, we strongly recommend you retain legal counsel to appropriately navigate the waters, to clarify what exactly they believe the issue with your medical record documentation is, or the claims and the billing and coding associated therewith, and help you get to the end of the OIG audit as quickly and painlessly as possible. Next slide, please. So we've got a couple more examples of criminal hospice cases. In the interest of time, I'm going to breeze through these with a little bit more brevity than I did the prior batch. But first on your screen is out of the Southern District of Texas. Company marketers falsely told patients they had less than 6 months to live. They also sent chaplains to the patients based on the false pretense that they were near death. To bill Medicare for these services, the company hired the defendant and other medical directors, but made payment of their medical director fees contingent upon an agreement to certify unqualified patients for hospice. I defy you to tell me what the government's Exhibit D was in the evidence, if they put that in writing. In addition to regular medical director payments, the defendant received luxury trips, bottle service at exclusive nightclubs, and other perks in exchange for his certification of unnecessary hospice patients. I am in the wrong line of work if they are getting bottle service for agreeing to commit fraud, but in exchange for these illegal kickbacks, the defendant himself certified over 18 million, with an M, in unnecessary hospice services as part of the over $150 million conspiracy. Next case on your screen is out of the Northern District of Texas, where an owner of a hospice and Texarkana agreed to pay $4.2 million to resolve allegations that it violated the False Claims Act by knowingly submitting False Claims Act, and knowingly retaining overpayments for the care of hospice patients in Texas who were ineligible for the Medicare hospice benefit because they were not terminally ill. I stress the word knowingly because that leans into a legal element we lawyers refer to as scienter or scienter. There's 100 different pronunciations around it. And it's relevant for the back half of this presentation when we start talking about the Anti-Kickback Statute and False Claims Act in full, which Lester will be presenting shortly. As a brief tee-off, next slide, please. As a brief tee-off, the Anti-Kickback Statute background was originally published in 1972, and these are the evolution of the scienter and intent requirements under the Anti-Kickback Statutes. The Omnibus Reconciliation Act of 1980 amended the Social Security Act to require proof of knowing and willful conduct, which takes us, I believe, Lester, to your slides.
Yes. Hi. All right, let's go to the next slide. All right, so anti-kickback statute. Criminal statute basically is trying to prohibit payments for referrals or certifications in our context here. There's a similar law called Stark Law that applies to home health and not hospice, but we'll focus just on anti-kickback today. So it's a crime to knowingly and willfully solicit, receive, offer, or pay any remuneration, which is basically anything of value, in return for referring or arranging for the services payable by any federal or state healthcare program, or two, purchasing or leasing, ordering, or arranging any goods or service. So what it does is, in the end, it catches both sides of the arrangement, so both the payer and the receiver. It doesn't matter if it's, either party can violate it. The person need not have actual knowledge of the section or specific intent to commit a violation. So that's where we kind of lessen the standard slightly. You don't have to really know about the anti-kickback statute. You more or less just had to know that you were paying something for a referral. And if only one purpose is in exchange for, the purpose of the arrangement is, improper, I guess, payment for referrals, then you violated the statute. But effectively, they've lessened the standard here for them to prove these cases. Go to the next slide. All right, so you can be sentenced up to 10 years in prison, fine up to $100,000, exclusion from participation in federal and state healthcare programs, and CMPs up to $50,000 per violation, and assessments equal to or not more than 3 times the amount of remuneration paid. So treble damages, $50,000 per violation, and that's per claim. So really, if they really want to pop you with one of these really badly, and you've got a ton of claims that you had filed pursuant to certifications, maybe by a medical director or someone you had paid kickbacks to, the amount of penalties that they can include as part of that case can be astronomical. Lots of times they'll only pick out 15 or so claims, and they like to focus on those. But if they pick more, you're doomed on the penalty side if you're convicted. Most courts have adopted expansive reading of the knowing and willful standard. So you have the Gerber Court stated that if the payments were intended to induce the physician to use cardiomed services, the statute is violated, even if the payments were also intended to compensate for professional services. So if one purpose of it was to obtain, get a referral instead of just obtaining, say, professional physician services, then you violated the statute. So you can't point to the fact that you really needed a medical director and you had to have one for regulatory purposes or whatever, and that's why you were paying him, or that's at least one of the reasons why you were paying him. If you were paying him too much, likely part of that, one of those purposes for paying above, say, fair market value would have been at least considered by the court to be one of the purposes to get a improper referral. So essentially, you can't just point to the legitimate parts of the contract and ignore the illegitimate parts. Go to the next slide. So because the anti-kickback statute is so broad and it kind of discusses, I guess, topics and covers topics that otherwise are completely legal and normal and no one really has a problem with, they created several safe harbors to protect conduct that potentially a violation of law, but would be permitted as long as you meet certain requirements. They're voluntary, not mandatory. So basically, failure to satisfy the elements of a safe harbor does not mean that you violated the statute. It just means that you're not protected from scrutiny, essentially. So the number of them changes all the time. There's currently 11 statutory ones and 36 regulatory safe harbors, but like I said, they either tweak them, recombine them, or add new ones all the time. It's a constantly growing kind of area. Every time, I guess, a really commonplace arrangement fails to fit within, the scope of one of the safe harbors, they end up kind of coming out with a new tweak. Lots of the EHR ones are kind of difficult to write for, so they've done new ones for those. For the next slide. There's a couple of them that your main two ones are actually these two right here. So the personal services and management contract safe harbor, that's for independent contractors, and employment safe harbors, obviously for everyone's a W-2 employee. There are rules to these two safe harbors, but that's the gist of them. You want to look at these as every single person who is a potential referral source or may send other business your way, that even if it's unrelated to hospice or home health, because the other business generated is one of the standards in, say, Stark Law and a kickback. So you want to make sure that every single one of those kinds of people, every physician, every hospital, any contract you have with anyone who may send a patient your way, discharge planners or doctors, you want to make sure that the contracts between your agency and them have been run through to make sure that they comply with one of these two safe harbors. In the next slide. So under the personal services management contract safe harbor, let's see, this is talking about this is the amendment. So essentially, under Stark Law, there was a similar independent contractor rule that basically one of its requirements was that the compensation had to be set in advance, and that's actually a requirement of the anti-kickback one as well. But in anti-kickback, the aggregate compensation had to be set in advance in the contract. In other words, like if it said, if it paid like a certain amount per unit of service or something, you had to actually describe exactly how many units were going to be provided under that entire contract, which is usually impossible because you don't know. So lots of contracts could not qualify for the personal services safe harbor. They could under the Stark Law version because it only set you only had to set the methodology for determining compensation in advance. So I guess seeing the wisdom of the Stark Law rule and how well it's worked over the years, they decided to amend the anti-kickback one to allow the same kind of aggregate compensation, not to be what the standard is. It's now set on the methodology. So you just have to specify exactly how many units of, dollars per unit of service or whatever the variable compensation method is. Remuneration doesn't include payments made by a principal to an agent as long as compensation, as long as services to the agent, as long as the following standards are met. It must be in writing and signed by the parties. It's got to cover all the services of the agent provides the principal for the term of the contract and specifies those services. So you can't just give a one-liner description of their services, general medical direction services. You'd want to say how many meetings or what meetings they're supposed to attend to, if they're supposed to help with revising policies. You would list all those specific services in there. The term of the agreement has to be at least not less than 1 year. The methodology for determining the compensation is set in advance, consistent with fair market value in an arm's length transaction, and not determined in a manner that takes into account the volume or value of any referrals or other business generated between the parties for which payment is made by Medicare or federal healthcare program. So this is honestly usually the one that lots of agreements can't completely comply with. We see this all the time. Sometimes you can build in additional safeguards to kind of prevent the risk from being too high, but you'll lose safe harbor protection here sometimes. The services performed under the arrangement do not involve the counseling or promotion of a business arrangement or other activity that violates state or federal law. I've never actually seen this one come into play. And then finally, the aggregate services contracted for do not exceed those which are reasonable and necessary to accomplish the commercially reasonable business purposes of the services. A good example of something that would violate this one is if there is a fair market value, say, lease between a referring physician and a hospice agency of maybe some additional office space, but that doctor's leasing, far more than is necessary. Actually, usually be the other way around. So the hospice leases, say, property from the physician, and they lease far more than they need, and that excess excess over what's reasonably necessary to accomplish the commercially reasonable business purposes of the services, that's what would be considered the kickback. So anything in excess of fair market value, anything in excess of what's reasonable and necessary to accomplish their business purposes, things like that, that's what they end up considering to be the kickback. So go to the next slide. So even if you have a contract that perfectly hits every, it's 1 year, and it's signed by both parties. It's at least a year. It meets all those other requirements. If it's for far too much money, or if it's for far too many services, you can also violate that way. Employment safe harbor is a little simpler. It's a bona fide employment safe harbor. It says there's no violation of the statute for any payment by an employer to an employee who has a bona fide employment relationship with the employer for employment in the provision of covered items and services. So a lot simpler. This one essentially just requires that they be, employed to provide services for you, covered items and services for you, and that they're an actual W-2 employee. There's not a fair market value requirement here. There's not a lot of other things. There's not a don't base the compensation based on the volume or value of referrals. So lots of times this is how you maybe pay doctors based on employed physicians based on the number of procedures they perform. This would protect that kind of a situation in, say, a physician group or if a hospital employs physicians. The Fifth Circuit found that safe harbor protection adopts the definition of employee set forth in 26 USC 3121 D2, which is basically just the common law definition of employee for tax and all other purposes. It generally looks at several different factors, mainly focused on who controls the job and the means and methods of accomplishing the job. So the hiring party's right to control the manner and means, the skill required, the knowledge of instrumentalities and tools, the location of the work. Is it, do they get to work from home, or is it at a central office? Duration of the relationship, how long has it been going on? Whether the hiring party has the right to assign additional projects to the hired party, the extent of the hired party's discretion over and when and how long to work, method of payment, their role in hiring and paying assistance, whether the work is part of a regular business activity of the hiring partner, whether the hiring party is in the business, provision of employee benefits, and tax treatment. So it's a big long list. Essentially, we're pretty good at picking out what it is. Usually, when there's someone who's an independent, treated as an independent contractor who shouldn't, it's someone who's a long-term employee, and sometimes it's just an employer trying to get around, employee benefit laws and things like that. I never recommend anyone even go down that road at all, because it's you never win with the IRS. It's always costly to fight with them, and you lose a lot of protection by not treating someone as an employee anyway under these laws. So I usually skew towards telling people to just go ahead and employ people rather than try to fit them into an independent contractor role if they're working there all the time. But obviously, there's lots of independent contractor agreements with, say, physicians or nurse practitioners or whoever who works in various companies. So it goes both ways, but I prefer the employed part, at least from a compliance standpoint. It's much easier. Go to the next slide. So what do they say? What does OIG say about fair market value? In 2015, they issue a fraud alert about physician compensation arrangements that can result in liability. They'd recently reached settlements with 12 physicians who entered into questionable medical directorship and office staff arrangements. They alleged that the compensation paid to the physicians under the medical directorship arrangements constituted improper remuneration under the anti-kickback statute for a number of reasons, including that the payments took into account the volume or value of referrals and did not reflect fair market value for the service to be performed. I don't know how medical directorship ended up taking into account volume or value of referrals, but somehow they claim it did. It could have been that just it was over fair market value, and sometimes that's what they'll argue, is that that's taking into account volume or value of referrals. That's why they paid over fair market value. It's unclear exactly in every one of these cases whether they actually had a per certification or per referral kind of fee in there. I doubt they did, but anyway, the OIG alleges that some of the 12 physicians had entered into arrangements under which an affiliated healthcare entity paid the salaries of the physician's front office staff. This is also a real common one. Sometimes an entity that receives referrals from a physician office will offer some employees to them to help, I guess, process. Usually the way it's described is they'll help process, the intake process for, where they're going to be referring the patient. So they essentially just make that referral process easier, but they end up really just acting as front office employees for the physician, and essentially the doctor doesn't have to pay for one of their employees. That's an obvious kickback. So because these arrangements relieve the physicians of a financial burden they otherwise would have incurred, OIG alleged that the physicians paid under these that the salaries paid under these arrangements constituted improper remunerations to physicians. They said they were an integral part of the scheme and subject to liability under civil monetary penalties law. So that means they tacked on a lot more than just anti-kickback violations. Go ahead, next slide. So recent kickback risk areas. Be careful when entering into any business arrangement with an individual entity that's ability to refer business to you. Continuing concern of government involves lease arrangements with actual or potential referral sources either way, like the hospice could be leasing land or a parking lot from a doctor as a referring physician, and they might want to pay $1 million a month for that, right? Not that much, obviously, but that would be a clear kickback situation. Engaging or employing a medical director who makes referrals to your hospice or home health is a common area of inquiry. This is extremely common. Lots of hospices will have a medical director who ends up doing certifications and things like that. It's not that huge of a risk. We just want to make sure that we safe harbor your medical directorship agreement with them, which is very easy to do if you have a qualified healthcare attorney. And sometimes we'll get a fair market value opinion. It depends on if it's a large contract or not. But you can't just look at a typical medical directorship agreement and say this should be $2,500 a month or $25,000. It depends on how much work that doctor is actually required to do, and is obviously reasonably necessary too. Having multiple medical directors can definitely raise risk. I've seen it make sense in a lot of areas where there's different departments. If you do have multiple medical directors, the overall payment to medical directors in total probably should be somewhat close to what one would cost you. And you definitely don't want to just say separate all the little functions and make 15 different medical directors just to make 15 doctors happy. Never fall into that trap. And lots of doctors will, ask to be medical director. They expect to just be named medical director of all of these different things because their buddies, they've seen their friends become medical directors of various different, side practices or businesses, right? Never fall into that trap. Only hire someone as a medical director if you think they're going to help you with the clinical and policies and all that inside your company. You want a medical director that actually does medical direction. You're wasting your time if you don't have one. So while old school dine and dash approach may be gone, bringing lunch and other goodies to a practice or office is still commonplace and potentially problematic. There's a couple of different safe harbors we can use to protect, that say drug reps and people like that use to protect some things like this. But it's always been a risk area. Participating in sham arrangements for loan or research grants or speaking fees, these are huge. Usually it's the large companies that are paying someone to come and speak at, do speaking fees and speak at some conference somewhere where it's actually a sham. It's not, I haven't seen that much with home health or hospice, but it is possible. Don't pay your medical directors or any referring physicians tons of money to do research or speaking fees without talking to a lawyer. If an individual entity has a financial interest in home health or hospice, to which it sends referrals, that can be problematic, obviously, especially if for home health with Stark Law. It's a little different than anti-kickback statute in the sense that if you violate Stark Law, it's strict liability. So you automatically, it's overpayment and there's penalties. There's no intent standard there. It is a little more detailed, so sometimes it's easier to determine if you're complying or not. And obviously under Stark Law, we would never have a contract that doesn't meet every single element of one of their exceptions, because they have exceptions under Stark Law, not safe harbors. If you don't comply with all the elements of a Stark Law exception, you violate the statute. Whereas anti-kickback statute, as we explained earlier, just because you don't meet a safe harbor doesn't mean that you violate the statute. So any giving of cash, gifts, and all that kind of thing, obviously, is a big risk area. Sporting event tickets. Lots of times, a friend, I guess the owner of a home health or hospice will, I guess maybe they are actual friends, longtime friends with someone, and they'll start inviting them to, rides in their jet or, their suite at a football game. That can be problematic, even if you have a long-standing friendship. If that person is referring business to that home health or hospice, then that's a big problem area. Go to the next slide. So now you can get false claims act liability for an anti-kickback statute violation. They're long viewed as separate, and usually instead of bringing just false claims act case, they bring anti-kickback statute in criminal cases. But over the past 20 years, they've slowly changed that. They've started in the early 90s, whistleblowers started beginning filing all kinds of KTAM suits under the False Claims Act that would typically be pursued as criminal cases. But the whistleblowers would uncover the wrongdoing and file it themselves. These cases also often involve fact patterns where a party was alleged to have violated an kickback statute and in the process billed for services that were worthless or medically unnecessary, and were made based on a false or express or implied certification to the Medicare and Medicaid program. And that's basically when you file a claim, you're certifying that everything on the claim is accurate and true and whatever. So 2010 passage of the Affordable Care Act got rid of the need to bootstrap a violation of the anti-kickback statute onto a violation of the False Claims Act. Under the ACA, a claim submitted in violation of the anti-kickback statute automatically constitutes a false claim. So basically, when you file a claim now, you're implying that it does not violate the anti-kickback statute. And if you're not telling the truth, that's a false claim. So next slide. So what this basically means for you guys is, if you violate the anti-kickback statute, you can also be popped with a ton of False Claims Act violations. And the fees and penalties can they can get really comically large, like impossible for anyone to pay. Prior to the 2019, expansion of billing privileges, revocation regulations. So in 2019, they expanded the reasons that they can revoke billing privileges. And they're pretty broad, frankly. They don't do this in every single time they find some kind of non-compliance with anything, but these are the basic reasons that they will cite. Basic non-compliance, provider or supplier conduct, felonies, false or misleading information, on-site reviews, misuse of billing numbers, abuse of billing privileges, failure to report things, failure to document or provide CMS access to documentation, so not responding to ADRs, initial reserve operating fund deficiencies, Medicaid termination, prescriptive authority, prescribing authority, improper prescribing practices, debt referred to the U.S. Treasury, so it's just an unpaid overpayment, revoked under a different name or identity, affiliation that poses undue risk. That's pretty broad. But these two are designed to catch people from getting popped while owning one business and then just starting a new business somewhere else. Billing from non-compliant location, abusive ordering, certifying, or referring. This is for doctors, essentially. Maybe they didn't bill for the service, but they ordered it or referred it or certified it, and patient harm. Let's go to the next slide. So additional proposed revocation authorities. CMS modified the existing regs. Now several other requirements must be met. They expanded the language to include all enrollment requirements, regardless of their placement in Title 42, so I guess any kind of condition of participation. Misdemeanor convictions, if the owner or managing employee or officer or director thereof has been convicted of a misdemeanor under federal or state law within the previous 10 years that they deemed detrimental to the best interest of the Medicare program. This could be things like maybe perjury, stuff like that. Well, it's usually a felony. Any kind of theft or something like that, even if it's not Medicaid funds, that could fall into this kind of category. False Claims Act civil judgments. I'm not sure why this wasn't ever on there before, but violation of provider or supplier standards. They've always been able to say reject application for new licensure, but they usually couldn't just revoke your billing reasons just for minor conditions of participation. There was, I guess, processes for you to be able to correct them, right? But if they want to, they could revoke it now. Debt referred to the Treasury. Again, this is basically any Medicare overpayment that hadn't been repaid. I haven't seen this a ton, but if you have a huge overpayment, it's probably what they would do eventually. Lots of times if you're continuing to bill though, and they're just going to recoup everything that they would otherwise pay you, and so they may just keep you on just to help pay down the debt, frankly. But go to the next slide. But if you're bad enough, they can revoke it entirely. So just talking about responding to investigations, it's always dangerous. Always for everyone involved. You never know what the FBI or DOJ or whoever, what their goals are. You have no idea when they're talking to you. You may be just a witness to something, but they may want to pop you with a charge too, in order for you, to exert pressure over you. So usually when they do interview you, they're not going to tape record it or anything like that. If you could, I'd suggest maybe doing that openly. But what they do is they just record, they take notes of the interview and they record it on FBI Form 302, which basically only represents their description of what you said, not your actual words, which can be very, and almost exclusively is damning towards you. It's just, they're not going to write this in a way that's flattering to you at all. So if you are approached by an FBI agent or anyone else, you cannot talk to them without a lawyer. You really just can't. It's far too risky. Go to the next slide. So, and here's why, mainly. You can't lie to government agents or investigators at all. So if they think anything you say just doesn't match up with their view of the facts, they can charge you with lying to them. Obviously, if they can prove that you're lying, then that falls into that category too, and they will charge you. But they'll do this lots of times just to exert pressure over, say, employees of a hospice or home health or something like that, right? And then they'll get that person to essentially say whatever the hell they want for the rest of the trial, maybe against the owner or something. But everyone gets popped when they talk to these people and you lie. So whatever you do, if you do talk to them, I would suggest having an attorney present and then talk through them. Failing that, definitely do not lie and don't overstate things. I think we have another slide here that says someone got charged when they said 99% of the time I do this, which is an exaggeration, and they got charged with a crime for that. So let's see, Supreme Court addressed these issues before, and basically they've allowed it most of the time. They essentially say in a couple of different cases that the use of trickery and deceit is permissible. Criminal activity is such that stealth and strategy are necessary weapons in the arsenal of a police officer. And another statement, no rule of matter of fact of deceit defeat a prosecution. So they can lie their butt off to you and tell you that you're not a target and we don't have any interest in you. We know you did everything right. And the whole time they're just trying to get you to admit to playing some part in the claim filing process or in the care process. They've already got in their minds something they want to charge you with. So it's just super risky to talk to them. So examples of that does shock the conscience was an investigator lying about his identity and introduced themselves as a court-appointed attorney. That's crossing the line. Investigator posed as a clergyman in order to get a confession under the guise would constitute behavior that shocks the conscience of the court or the community. And they've upheld countless confessions, even though the investigator lied to the defendant during the interview. Typically they're allowed to do anything they want there and trick you into confessing or trick you into saying something that puts you in further jeopardy. Go to the next slide. So misstatements, hyperbole, exaggerations can result in prosecution. So this is a case involving someone who said 99% of the time he checked the vital signs of a patient before prescribing an opioid. When truth in fact that was just terribly false, and it was definitely not 99.9% of the time at all, not even close. So they didn't charge him with billing or any prescription violations. They just charged him with lying to the FBI, which is 5 years in jail, $250,000. They can also call it, I think, interfering with an investigation or something like that, and they can sometimes charge up to 20 years. So it can be catastrophic to talk to them. I tell people, don't talk to the DOJ or FBI or anyone like that for any reason, not as a witness, not without a lawyer, not as a witness, not as a next door neighbor, not as anybody. Just don't do it. Not as a victim. Even victims have been charged with lying to the FBI because the government didn't believe part of the story that they told, which is kind of crazy. You're trying to report some crime and then they charge you with the crime, but it's happened. So just be careful when talking to the feds. They've got this tool that no other law agency really has, or at least it's exercised as aggressively as they have, and it's not fair. So go to the next slide. So final thoughts. Self-audits, not just encouraged, you've got to do them all the time. You don't want to end up finding out about a situation you could have fixed, right when you find out. You don't want to just have that go on for like 2-3 years and cause a giant overpayment when really it's a paperwork error. You didn't have all the right signatures, or you're doing something on the wrong date. You can fix that if you find out about it. So constantly self-audit and, question your own people's kind of billing and documentation and try to improve it all the time. Anytime someone raises a red flag and says, I think we billed, they say something and say, oh, well, this patient, we don't have a physician certification. Well, that's a potential overpayment. You need to immediately investigate that and return the money if you've already billed, if something's not fixable, for instance. Remain mindful of the DOJ's interest in individual accountability. So meaning they're not just going to charge, say, a company and just bankrupt it. They're going to go after the individual officers. It's not just always going to be the owners. It's going to be the administrator or the billing person, whoever's involved. They'll pop. And sometimes they'll strike deals and cooperation deals and get their charges reduced. But you don't want to be charged. I mean, your life is completely upended if you're charged with a federal crime. So, don't even when you get, like, say, non-DOJ led kind of audits, know that they're sometimes in the background watching it. So don't alter any records, don't commit any crimes in the conduct of you responding to an audit. It's ridiculous. It's the dumbest thing you could possibly do. If you're missing something in the records that can't be fixed under Medicare's rules, then it's just not fixable, and it just is what it is. If you got to pay back the money, you got to pay back the money. Don't do anything to cure that documentation, especially not without a lawyer. There are some ways we can fix some things, but it's very hairy, dicey for you to do it. So contact an attorney if you need to do something like that, and always document everything you do. All your efforts to comply. I find that one thing I always tell clients is sometimes everyone is expected to have some errors and have some mistakes. There's too many regulations and rules that apply to us. So sometimes what's most important is how you respond once you discover a problem. Make sure that, just always keep in mind that however you do respond in a way that you'd be proud to stand behind if you're questioned on it by the DOJ one day. And I think that's it.
All right, so just to wrap up real quick, we do want to repeat a disclaimer that we gave at the beginning of the slide deck. This outline in the slide deck is provided as general information only. It does not constitute legal advice and should not be substituted as a legal counsel. If you would like to work with either one of us or our firm, we can be reached at our emails on screen or the number on your screen. We'd be happy to help you with your healthcare regulatory concerns as they come up, but we do need to talk with you about your case specifically. We cannot give you general advice, anything more than general advice, over the course of this webinar. And I believe that takes us to questions. Gia, do we have any questions that we're waiting on?
No, we do not have any questions at this time.
All right, I think that will take us to close then. And on that note, thank you everyone for joining, and we look forward to presenting with you in the future. Thanks everyone for your time.
Thanks, bye.
So yeah, that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Matt and Lester. Everyone from today's webinar will receive copies of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to the speakers or directly to Lyles Parker. Have a good Wednesday and take care.